Let me welcome you all to Harvard Law School, the historic Ames courtroom. My name is Charles Ogletree. I'm the Jesse Klamico Professor of Law here at Harvard, but also the founder and the executive director of the Charles Hamilton Houston Institute for Race and Justice. We opened our doors right here in this Ames courtroom in September 2005, and since have held a number of remarkable public and free events talking about justice and race. And my team, who's been with me since the beginning, have been an integral part. Dr. Susan Eaton, who's our director of research, and Johanna Wald, who is the director of strategic planning and development, as well as David Harris, who's the managing director. I think David and Johanna are here. And both Ernest Owens, who's done a terrific job in organizing the technology for this event, and Kelly Garvin, who's been our pinch hitter for everything that we've done, makes a big difference. We're very happy as well to have with us Laura McNeil, who's a PhD and a JD, who's a fellow who spent this past year with us and worked on many, many of our important projects. So let me tell you what's in the future and then say a word about this conference before introducing Justin, who's the brainchild of all of it. In addition to what you'll see today, we have an annual public event. It's on August 15th. Some of you know, have talked to me about it, on Martha's Vineyard. Every year we have a major event. It's called Between the Lines, Race, Gender, and Sports in America. And we have a wide range of very significant people. John Carlos, you may remember from the '68 Olympics, will be coming. His mentor, Dr. Harry Edwards. We also will have Scooter McClure, an African-American who won a gold medal in boxing in the 1960 Olympics and also received his PhD that year. And we have a number of other prominent folks who will be remembering and who will be participating in the program as well. Going even further, in 2007, some of you came to an event we held here at Harvard. It was an examination of the Dred Scott case on the 150th anniversary of its decision in 1857. We're, in a sense, rekindling that and examining the issue of education and opportunity on October 12th through the 14th, 2012. We're going to have a re-examination of Aaron versus Cooper. The non-lawyers and lawyers will know that that case is about Little Rock, Arkansas, and the Little Rock Nine. We'll have many of them coming talking about their experiences the last 45 years. And we have a remarkable panel that will examine some. Our topic is going to be, did President Dwight Eisenhower really favor or reluctantly favor the issue of integration of public schools? And we have experts who will testify about that, and then we'll have an argument before a Supreme Court. It will be chaired by our Chief Justice for this program will be Supreme Court Justice Stephen Breyer. We have a number of other circuit judges from around the country, including one who was here today observing this program, and I promised her I would not call on her and identify her, but I will. I hope you'll welcome to Cambridge from the Sixth Circuit Court of Appeals, Judge Bernice Donald. Judge Donald, I know she's here somewhere. Right, there she is. The circuit courts have changed, so, and we have Judge Roger Thompson from the First Circuit, and a lot of other circuit judges, James Graves from the Fifth Circuit, and it's going to be a very impressive program. All of our programs, you can register and be on our mailing list. It's www.charleshamiltonhouston.org, www.charleshamiltonhouston.org. So we hope we'll see you at some of these other programs. Now this is an event that has been in the making for a few years. I had the honor when I was on sabbatical a few years ago to visit the University of Hawaii and met Professor Justin Levinson, who had this idea of a conference on implicit bias. And I said, you know, I don't think people are ready for that. He said, I think they are. And he and Rob Smith and others have put together a remarkable book on it, which will be available later this morning, available at lunch for sale, and available at the reception as well. And you will see we have the country's experts in every conceivable field who will be talking to us today about this issue. And we hope that you will engage our panelists, learn more about it, spread the word that we are not calling people racist or sexist or homophobic, but the whole idea is that people have unconscious bias that they don't know about. And we're trying to make sure that it's more part of law, sociology, psychology, and you're here from some of the country's leading experts on it today. In fact, the first panel will give you a nice overview with Dr. Banaji and many others who are participating. And we're going to look at it from every conceivable aspect. And the person who does it, he really is a tenured professor. He really is adult and married. I know he looks 12, but it's just your implicit bias that makes you think that he's a young guy. He is an established scholar, a phenomenal teacher, a great progressive leader, and we're very happy to have this program, Implicit Racial Bias Across the Law. And please welcome to our podium the leader of this event today, Justin Levinson.
Thank you, everyone. I want to thank everyone for coming. I want to echo Professor Ogletree's thanks of all the folks from the Charles Hamilton Houston Institute, particularly David Harris, Johanna Wald, Kelly Garvin, and Ernest Owens. This event is really a tribute to them. I want to briefly talk about where this conference came from and where I hope it can go, and then I want to turn it over to our outstanding panelists for the day. The purpose for this book came about following a social science revolution that's occurred in the past 2 decades. There have been amazing developments in social psychological research on how to measure automatic cognitive processes that cannot be controlled. What is happening in the human mind, right? It's not always what we're aware of. And what are the implications of these when we're talking about people from stereotyped and traditionally disadvantaged groups? Legal scholars were slow to pick up on this outstanding research. We have many legal scholars here today who were the least slow to pick up on this research, but part of this book was written as a challenge to the legal establishment, to the law and policy establishment, to recognize that we're not picking up well enough on this social science research. So the book is called Implicit Racial Bias Across the Law. The reason the book is called that is because most of the legal work on implicit bias, both racial bias and all other kinds of bias, most of the work has been focused within employment law, some on criminal law, and then just a smattering of other projects that have gone in depth considering implicit bias and its implications. The breadth of implicit bias has yet to be adequately covered. The depth of implicit bias has yet to be adequately covered. Part of that is due to the fact, in my opinion, that we don't have enough social science targeted specifically at the areas of interest of legal scholars. We certainly have an amazing amount of social science that's established these principles, and it's one of the most exciting developments that I've seen in my lifetime. But within the legal establishment, I think we're not there yet. We're making progress. This book I consider to be, along with all of the other projects that many of my colleagues have finished, I consider this to be one of the early steps. And I hope this event can use the book as a starting point so that we can launch a coordinated effort, that we can create new collaborations today, and begin to ask ourselves and continue to ask ourselves some of the harder questions about what do we do about implicit bias across the law. So having said that, I just want to briefly mention a couple small attributes of our program today. This morning, we're all in Ames courtroom. There'll be 3 panels. The first panel is psychologists who will be talking about their work. We have 6 superstar psychologists here today, 3 of whom will be on the first panel. We also have 3 award winners. These are social psychology graduate students who have won the Emerging Implicit Bias Scholar Award that the Charles Hamilton Houston Institute put together for this conference. We'll be introducing them in the afternoon. And then after that panel, we have a panel that really celebrates the book and celebrates some of the contributors to the book. This book would not have happened without these contributors. They're fabulous. Their work is amazing. It's interesting to see these contributors in their conversations because some of them have been engaged in legal discourse about implicit bias for quite some time, including leaders. But others have been dealing with the struggle for racial justice using other avenues to explore the topic. They haven't yet engaged in implicit bias conversations until this book. So it's very exciting to have them here, and to have this, the second panel will be wonderful. The third panel is unique in that we have 2 federal judges, one sitting federal judge and one retired federal judge, joining a psychologist and 2 top legal scholars to have a conversation about the various aspects of implicit bias and even social psychological work more generally in the courtroom setting. In the afternoon, we're going to work hard to get the audience involved. We don't expect a passive audience for this event. Audience participation will be crucial in the afternoon sessions because we have 4 simultaneous sessions focusing on education, criminal issues, another panel exploring the breadth of implicit bias, and also a panel on implicit bias within organizations. Okay, so we have 4 areas of depth that we're concentrating on. Each of those panels will be followed by facilitated discussions with the audience and the panelists to explore further some of the topics. Then we'll meet back here to really crunch what happened in those 4 simultaneous sessions, explore new ideas, and hopefully we'll be excited and not tired as we wrap up this event with refreshments and beverages at 5 o'clock. So I'd like to now call up the panelists from the first panel, and we're just going to launch right into this. I'm the moderator for the first panel, so can the first panelists come on up? And I'm only going to use brief introductions for our first panel because I want to save most of the time for them. But let me conclude the welcoming remarks by saying that I hope that you're at least a percentage as excited about this event as I am. I think this is really a unique opportunity to bring together a fabulous group of people. And in conclusion, I realized I forgot to thank Rob Smith, my co-editor on the book project. This book wouldn't have happened without Rob. His energy is contagious and amazing. So thank you, Rob. Okay, so let's begin panel 1. Our first speaker today is Dr. Mahzarin Banaji. Most of you, I'm sure, have heard of Dr. Banaji and her outstanding work. The first piece that I ever read of hers was a book chapter she wrote called Implicit Attitudes Can Be Measured. It's such a simple title, but when you think about the concepts underlying that title, it's really important because in the 1980s, we had a pretty good idea that the unconscious processes of our minds worked in ways that would be concerning. And my colleague Charles Lawrence was one of the first in the legal domains to explore that. But we didn't have a strong social scientific understanding until the 1990s of exactly how implicit attitudes can be measured. So Dr. Banaji, among other things, is one of the inventors of the implicit association test, which is extremely famous today. She's a professor of psychology here at Harvard. And there is a long list of awards and accomplishments and fellowships, which I am skipping over, and I will let her talk speak for itself. Welcome, Dr. Banaji.
Thank you very much. It is an honor to be here. Thank you, Tree. Thank you, Justin. I'm delighted to be with 2, 3 very good friends of mine here on the panel. And mostly, I'm just very honored to give my first talk in a program that is hosted by the Charles Hamilton Houston Institute. You know this man's name, but I just want to begin by saying that he is famously known, Charles Hamilton Houston, as the man who killed Jim Crow. He is practically the inventor of civil rights law, and he believed very strongly that he had to use, it was his job to use every ounce of the power of the law to fight on behalf, as he said, of those who could not strike back. With that, let me just say that that's the law side of what we will talk about today. But I am also reminded of something that Martin Luther King Jr. said 3 days before he was assassinated. He gave a major keynote address to psychologists at the American Psychological Association meetings. And the one phrase that has stayed with me since I first read that speech is MLK's advice to social scientists. And he said, what you can do for us, what you can do for civil rights and for the movement, is to tell it like it is. And I have taken this seriously in my own work, to try to tell it like it is as hard as some of those discoveries have been, including discoveries about what lies in my own mind. All of this comes together in this book that we are celebrating today. And when I saw it, my first thought was, who would have thought that this was possible? So Justin tells us the law has come very slowly to these ideas. I actually think it's come incredibly fast for being the law to these ideas. I mean, there are people in this room who got it right away. Linda Krieger is in the room, and she really is a hero in this sense. But I really was pushed in this direction by my colleagues, both at Yale Law School and at Harvard Law School. They were the ones, far more radical than I, who said, there's something in these ideas that is going to change the way in which the law will think about this, and you should not take it in that direction. People like Bruce Ackerman and others believe that we should get police officers to actually wear their daily IAT scores on their badges every morning, and so on. And I won't go so far, but I think that I appreciate that sentiment. So let's see. I just want to say that I don't think that the framers of the Constitution could have ever fathomed somebody like Homer Simpson, right? They would not have necessarily been able to know, not that there weren't Homer Simpsons then, there were, because every one of us is a Homer Simpson in one sense or another. But the important thing that the framers did not know about is that we could understand our minds in the ways in which we understand them today, and to know that there are things inside of our heads of which we have no conscious awareness, okay? So think about the framers and their beliefs about the way in which the Constitution should have been put together as they did. And the one, I mean, this comes back to me regularly when I think about somebody, a visionary like Benjamin Franklin, who actually believed that, and argued, that public officials should just run for public office and not be expected to be paid a salary, okay? So just think about what this means. In Benjamin Franklin's mind, nobody who was not incredibly independently wealthy should ever have run for public office, right? So this is how different their minds were than the people that we are today, and I just want us to keep that in mind, because the science has been showing us all of the ways in which many of the assumptions the framers made about who human beings are, and to some extent the assumptions that the law makes about who human beings are, simply isn't correct to the facts of who human beings actually are. Many of you know the trolley problem, and I'm not interested in telling you in detail about it, other than to pull out one little piece of this famous kind of puzzle that has been used recently, not only by philosophers, but by neuroscientists to try to understand how our minds make complex moral decisions. So most of you know that in this trolley problem, if we said to people, if this trolley's brakes have failed, and if it's going down the path it's supposed to be on, it's going to kill these 5 people, but our moral decision maker here, headless though he is, he can make a choice, and that choice could be to switch the train to go down this other path, thereby killing only 1 workman. And when people all over the world are asked, what's the right answer? What do you think you would do, or what do you think he should do? Most people are fabulous utilitarians. They think about the greatest good of the greatest number, and they argue that what he should do is flip this lever, letting these 5 people live and letting that 1 person die. As hard as that choice is, that to most people seems like the right thing to do. But of course, we can trap people by showing them a slightly different version of this problem in which there is no alternate path, where these 5 people who lie in the way are going to die because the brakes of this train have failed. But then you ask them the question, in this case, life poses an interesting opportunity to our decision maker. He can, of course, push this man over this bridge. He will fall, the train will hit him, and he will die, and these 5 workmen will be saved. And the question is, should we do that? And most people in the world quickly become non-utilitarian. They say, absolutely not, that's not the right thing to do at all, except some economists who will say, yes, you should push, because they will say, well, you've got to be rational, don't you? But it is an interesting question for all of us. Not so much that there is a right or wrong answer here, but the fact that we are inconsistent. The fact that we are strong utilitarians in one case, and we become Kantian deontologists in this case by immediately giving importance to the rights of this person. Okay, so far so good. My colleague Josh Green and many other people have done gorgeous work on what our brains do when we look at one versus the other problem and so on. But my interest has been in this question, of what would happen if the people who were about to live or die were not human beings, but were some other species. And in the very first paper that was published on this topic a long time ago now, that condition was indeed included. So imagine that this problem is set up so that there are 5 chimpanzees lying in this path here, 1 chimpanzee there. What should we do? The answer tends to be exactly what we would say for human beings. Save the 5 chimpanzees and let the 1 chimpanzee go. So no difference in what we say about the fate of chimpanzees versus what we would say about the fate of human beings. Okay? But now when we have this problem here that's a little bit different than the first one, in which we are not utilitarian, here is the problem. 5 chimpanzees lying here who are about to die, 1 large chimpanzee standing on the bridge. Question is, should you shove this 1 chimpanzee over to save the 5? What do you think? A lot of you nice people are nodding your head and saying, let's shove that chimpanzee over, because there seems to be something good about saving 5 chimpanzees. And I can tell you, chimpanzees are not a nice species. They're violent, they're awful. But yet all of us want to really save these 5 chimpanzees all of a sudden because we think it's okay to shove that 1 chimp over. So the question for us is this: why? Why does it make you and me feel that it's actually somewhat okay to shove that 1 chimpanzee over and save these 5? Why, when the creature is not like ourselves, do we become utilitarian? Why is it that to us the rights of this chimpanzee somehow matter slightly less? And to what extent can we change who that person is and notice some of these sorts of effects? So I'll show you the results of just one study, not using the trolley problem, but instead, this is a composite brain image. It is constructed out of the brain images of many different people who were in an experiment that we did. The lead person on this study is Jason Mitchell, a colleague of mine, and we were interested in how people would respond to information about 2 different people, different only in one way from themselves. This being the People's Republic of Cambridge, we introduced subjects to 2 individuals, one of whom was a liberal, the other was a conservative. And because we have very little time, I'm not going to give you the details of the study, other than to tell you that there are 2 interesting results that emerged from this analysis. First of all, when you put people in a magnet and you scan what their brain is doing when they're thinking about these 2 people, one of whom happens to be like themselves, the other of whom happens to be a little bit different from them, what you find is the brain actually allocates different aspects of neural real estate to doing the thinking about them. This itself stunned us, because I would never have predicted that the brain actually would take that into consideration sufficiently to allocate different parts of neural real estate to think about the person who is similar to ourselves and then the person who is different from ourselves. So when liberals thought about the liberal other, they used these blue neurons that I've colored here in blue to think about that person, but they use these neurons that I've colored in red here to think about the conservative other. Conservatives do exactly the same and opposite thing. When they think about conservatives, they use these blue neurons to think about them. They use these red neurons to think about the liberal other. Okay? So what is the importance of this separation, actually, I think only gets magnified when we realize that these blue neurons are very, very special. These blue neurons are also, we know, the neurons that we use to think about ourselves. Okay? The object in the universe most special to ourselves is ourself. And those are the neurons that get used to think about others who might bear some similarity to us. In other words, think about having some kind of an invisible moral boundary that you draw around yourself. Some people are able to permeate that boundary, and it could be because they share some beliefs with you, it could be because they look like you, and whatever it might be. We know that these neurons are special because they have back projections to other parts of the brain. If this were a computer, we would argue that the bus between these neurons and other centers of the brain that give us the feeling of empathy or sympathy, in some ways trying to understand what that other person is suffering, that these neurons are specialized to be able to provoke that. So this is a non-trivial, I think, this discrepancy, and I use this graph in particular when I talk to judges, because I'm quite sure that judges, when they sit there thinking about this other person, are doing everything possible in their power to make a decision about this other person, irrespective of of whether that person is similar to them or dissimilar to them. And yet, because the judge's brain doesn't hurt when they're thinking about the different person, it is quite possible that these neurons, which get activated in the case of who that other person is and the similarity of the person to the judge, that these may provoke fairly different kinds of decisions. Okay, this is of course true of all the judges in the world except the 4 who are in this room. Okay, here we go. I am going to argue that this similarity to self idea is actually a quite powerful one. That when somebody looks like us or thinks like us, that this is something that the next phase of implicit bias work is going to have to look at, just the variety of ways in which we and others share something in common, not just physical characteristics, but something as simple as whether we've lived in the same zip code as this person and so on, that lead to certain kinds of benefits accruing to those who are like ourselves. I say this because I actually think that the idea has in it the possibility of changing how we think about discrimination. We tend to think about discrimination as negative actions towards an outgroup. But I'm here to tell you that these days, less and less, we go around burning the churches of members of groups other than our own. That's not the way in which we discriminate. I'm going to argue something that I think is going to be a little radical, and that is discrimination proceeds by helping people like ourselves. That is largely the way in which it happens in societies like ourselves, and that's why I think that the implications of that for how we behave and the actions. So think about this act. The act of helping is an extremely positive act. We want to do it. And yet I'm here to tell you that how you apportion that act of helping may itself be something to think about. When we began to do work on implicit bias, it often came to us in a striking enough way because we showed the bias ourselves. I'll give you an example of mine, and I think you will share this particular bias. This is an array of faces that appeared in a paper that Dan Levin wrote some years ago. Dan Levin is a person who's interested not in people but in objects, usually, and he's interested in brightness, the brightness of an object, you know, how much light shines off of it, okay? And Dan published this paper in which he had created these computer-generated images that he noted in his article varied only in features, going all the way from more Eurocentric all the way to more Afrocentric features. And in Dan's paper, there was a footnote under this that said, I held the skin color or the brightness of the faces to be constant. And when I looked at this image, to me, the skin color on these faces did not look the same. And so I wrote an email to Dan, and I said, Dan, I think the journal or you made a mistake, which you might want to correct. The skin color on these faces is not the same. And he sent me back in the flash of a second the Adobe Photoshop file containing these faces so that I could verify for myself that the skin color on these faces indeed is identical. So my brain does not see these people to have the same skin color, and the only reason that happens is because I automatically assume that features of this kind are associated with darker skin than features of this kind, okay? So these are biases that lie deep within us. I suspect that all of you in this room see it. And I think it all begins from something as minor as this to when we decide whether we trust somebody, whether we think that they're competent or not, whether we think that they're dominant or not. And here I just want to mention the work of a brilliant psychologist, Alex Todorov, who's been showing us that indeed when we look at human faces, we very rapidly make decisions about all sorts of things. Within a third of a second, okay, we make decisions about how trustworthy somebody is. We make decisions about how competent they are. We make decisions about whether they will dominate us or let us dominate them. All of these old primitive kinds of decisions. There's only one problem with this. It doesn't seem to have very much bearing on whether the person is actually trustworthy, whether the person is actually competent, whether the person will actually dominate or not. And I'll just show you very quickly this one video where all Alex does is changes the eyes. Am I 2 minutes? Okay. Changes the distance between the eyes, and what he will show, what you'll see is, you'll begin to see that the person, as the eyes move away, we think people look smarter and smarter. And as the eyes come in closer and closer, most of us, if we're honest with ourselves, will agree that the person starts to look like they're dumber and dumber and dumber, okay? And I want you to actually ask yourself whether you see this or not. So look, the eyes move, whoops. Oh, okay, I'm sorry. I can't show you this video because we moved this to a new computer, but I can do this during break if you're interested. The important thing is to know that we all show this, but it predicts the margin of victory in elections. Okay, so this assessment Your assessment of how competent a face looks, not whether the person actually is or not, but your assessment of whether the person is, predicts the margin of victory in elections. Okay? All right, so I'm going to actually take us to this one last slide that I want to show you. Justin mentioned that we've done work on a test called the implicit association test. And in the last several years, not we, but many, many, many other people have done beautiful work showing that the score on the IAT predicts behavior in the real world. And the kind of behaviors that we're predicting are nonverbal behaviors of discomfort. So the stronger your anti-black bias, the more uncomfortable you will actually look to a neutral third-person observer who's watching a video of that interaction. The more it will affect your ratings of the performance of that person, the less you're likely to hire candidates for a job who come from that group, the more likely you are during an economic downturn to cut the budget of people who come from that group. And in this last study that we did in Boston, we showed that doctors who are in some ways the purest of the pure, these are doctors who work in a relatively poor hospital, they treat people who do not have health insurance, they are, we might say, doing God's work. But we gave them the IAT, measured their race bias, and then sent them pictures of patients who had certain symptoms that they were expressing and asked the doctors to decide whether to prescribe thrombolysis or not. Thrombolysis is a clot-busting procedure that's prescribed in about 50% of the cases with people who have these symptoms. And we report in a paper that we published in the Journal of General Internal Medicine that doctors with higher IAT race bias, that is, the more anti-black the doctor is on our test, not in what the doctor says, because the doctor is not consciously biased, okay? But the degree to which the doctor shows a higher race bias on the IAT, the less likely that doctor is to prescribe thrombolysis to a black patient with equal symptoms to a white patient. All right. We can't say it as well as poets can, so I'll just tell you this because so many events, including Trayvon Martin and others, remind us of what Adrienne Rich said in her poem, Midnight Salvage. She said, "Lucky I am, I hit nobody old or young, killed nobody, left no trace, practiced in life as I am." And I think I'm here to tell you that that's what we're interested in today. We're not interested in people's goodness or badness or evilness. We're interested in the fact that we all get practiced in life in certain ways. And because it's practice, the good news, the optimism here, is that it's possible to practice a different set of cognitions. So I'm just going to end by saying that we in science can and should continue to tell it like it is. You in the law should continue to fight and speak on behalf of those who cannot strike back. Thank you.
Thank you, Dr. Banaji. Our next speaker today is Dr. Patricia Devine. Dr. Devine is joined up here by Patrick Forsher. Patrick is one of our award winners today, and we will give him a better introduction later, but that's who's up here with Dr. Devine. Patricia Devine is a professor of psychology at the University of Wisconsin. I think perhaps she's most, at least when I think about her work, I think first of her late 1980s work on unconscious priming. 1989 was the big paper was published in 1989 on that. If you look at legal scholarship today, interdisciplinary legal scholarship, you'll note that the exact methods she used in 1989 to unconsciously racially prime are being used today. Jeff Raklinski and colleagues at Cornell used the same exact method to test trial judges and published that article just about 2 years ago. So the impact of her work on priming and other implicit social cognition methods is extremely significant, not only in psychology, but already in the law. So I'd like to, she also has a long list of awards and affiliations, which I'm skipping. But I'd like to introduce Dr. Devine.
I want to thank Justin for inviting me to share some of the work that I've been doing. Patrick's going to join me in this presentation because he's been a full collaborator in the work that we're going to talk about. So we're going to talk about something that I call breaking the prejudice habit, trying to address a societal level problem with an individual level approach. And to set the stage for this, I want you to take a look at a quote that was in an article in Time magazine by Touré, where a person came up to him while he was giving a presentation and said, "I'm a racist," whispered in his ear, "I'm a racist." And then he engaged her in a full conversation in which she confessed to him these kinds of thoughts. "I just have these thoughts. My mind just goes places. I can't control it. I know it's wrong, but I can't help myself. I say, don't think like that, but it's what people told me when I was younger. It's this kind of conflict between people's conscious views of what they think is right and wrong and these more implicit, automatic kinds of responses. This very quote could have been written by one of my research participants in this 1989 article that Justin talked about, but this is still a problem that's ongoing today in 2012 in people's minds. They're wrestling with what they know is right and the types of immediate reactions they have. This is the focus of my work. The question is there anything that the social science work can offer to these individuals and perhaps others who want to embark on the challenge of breaking the prejudice habit? You'll see that metaphor come up. I'm going to ask Patrick to provide some background and set the stage, and then I'll come back and tell you about the specific empirical work that we've done to suggest that we might be able to offer this woman and many others assistance in their efforts to break the prejudice habit. Patrick?
Thanks, Trish. So one thing to note about this general conflict between people's conscious minds and what they actually do is that we haven't always thought about this conflict in that way. Initially, actually, when people were trying to address the problem of lingering racial disparities, they targeted overt observable acts of discrimination. This is a pretty rational approach, actually, because once upon a time, signs like these were commonplace. So separate bathrooms for black people and white people, separate waiting rooms, and so forth. So the initial approach that people took to address racial disparities was to target these observable acts through information campaigns, legal challenges, and so on. By definition, these efforts required a fair amount of social control. But the good news was that, at least by some metrics, these campaigns had positive impacts. So signs like these are no longer commonplace. And in fact, within the past couple of years, we've seen events that at one point would have been unimaginable. So for example, we have a black president. However, by a few other metrics, more subtle, well, not all subtle metrics, these types of campaigns, legal campaigns and so forth, have not been entirely successful in their original goals. Black people still experience more adverse outcomes than white people on a wide array of outcomes, ranging from employment to health to well-being to discrimination. So because targeting these overt observable acts hasn't been entirely successful, social scientists have turned to more subtle forms of discrimination as potential routes for how these biases get perpetuated. So one example of this was, well, I'm going to actually cite a paper by Marianne Bertrand and Sandal Mullainathan. They looked at callbacks on resumes that people send to different employers. So if you think about it, this is kind of an ambiguous situation. Perhaps you've got a pretty big stack of resumes, and it's not entirely clear what differentiates one really good candidate from another really good candidate. So the strategy that Bertrand and Mullainathan took to investigate whether there was a bias in employment callbacks was to develop a pretty large bank of resumes from online sources like monster.com. Once they had this bank of resumes, they randomly assigned each resume to have either a black-sounding name, so think something like Jamal, or a white-sounding name, so think something like Emily. They then sent these resumes to a wide array of employers from the Boston area, actually, and Chicago. What they found, I think, was pretty dramatic. When they measured the rate of callbacks for each type of resume, they found that the resumes that had the black-sounding names received only 2/3 the number of callbacks as the resumes with the white-sounding names. Now, if you think about it, this isn't the actual interview. It's only one step in the interview process, so that might not seem like a big deal. But if you think about how this kind of bias might play out over the course of a person's lifetime, it could have dramatic consequences for their overall career trajectory. So because it seems like subtle discrimination, at least, is still alive and well, social scientists have been forced to grapple with the problem of the source of that subtle discrimination. From my perspective, there are two primary possibilities. One is that the subtle discrimination is caused by some sort of external factor. It might be something like the way institutions are structured might subtly favor white people over black people. This is the idea of institutional racism. Another potential explanation is that there's some sort of internal factor that perpetuates these biases. As psychologists, people like Trish and I have focused on this internal factor. One potential internal factor that might be important is that people's intentions might not have changed. So if you think about the laws that prohibit discrimination, they might have been successful in changing people's overt behavior, but in the end, all these people might still be racists. So they might still intend to discriminate when either the legal sanctions aren't salient, where they can't be caught in the act of discrimination, or when their behavior can't easily be attributed to the intention to discriminate. So in that kind of ambiguous situation, like having a stack of resumes and not having good criteria to select one person over another. This explanation has been popular at one time, but to my mind, it flies in the face of survey evidence that has shown that across a wide variety of indicators since the civil rights movement, people's attitudes, level of stereotyping, et cetera, have improved rather dramatically. So I'll show you a couple graphs that illustrate this point. This is 4 common stereotypes about black people and the percentage of people that endorse each stereotype across time. And as you can see, from 1933 all the way down to 1995, when the data were last available, the percentage of people that endorse these stereotypes have consistently declined, with the slight exception of that spike in the lazy stereotype in 1995. Another form of evidence stems from people's responses to questions like, would you vote for a black candidate for president? And as you can see, at least according to the Gallup data, the percentage of people that endorse this item has also consistently improved or increased across this span of time. So to me, this kind of evidence says that people's intentions have changed. It's not that a whole bunch of people are secretly racist. It's that there's some other kind of internal force that's coming in between people's intentions and their actual behavior. Basically, it's preventing them from acting fairly as they intend. So one potential candidate for this internal factor that's severing the link between intention and behavior is implicit bias. So Mahzarin and Banaji has already discussed a little bit about implicit bias, but implicit biases are prevalent. They exist even among people who intend to act fairly. And at least according to some data, about 87% of all white people possess some sort of implicit preference for white people over black people. So the one approach that you might take to reducing lingering racial disparities is to reduce people's levels of implicit bias. Many people assume that implicit bias is caused by lingering stereotypic portrayals of outgroups in the social environment. So one potential approach to reducing implicit bias is to basically reduce the prevalence of those stereotypic portrayals. The idea is if you cut off the implicit bias at the source, it never even develops and it won't perpetuate itself in people's behavior. Some people propound this approach as a good one, but to my mind, it seems to require an even greater degree of social control than the legal efforts from the 1960s, because you have to control people's local environments, maybe even their interactions with their friends. So to me, that degree of social control is maybe even impossible and perhaps even undesirable. So another approach is to take an individual level approach. Basically, you harness people's good intentions that I described, and you give them tools to reduce their own biases. Enacting individual level change is perhaps no small feat, but as Dr. Devine will describe, it is possible.
So So in fact, we have taken this second kind of approach, try to focus on individual level factors to reduce bias. And in my work over the years, I've conceptualized these types of implicit biases as well-learned habits. They've been learned early in people's socialization experiences, owing largely to the saturation of stereotypic portrayals in the media and in people's experience. And they've been frequently activated, and they are the kind of immediate go-to types of responses. One of the things that we'd like to suggest is that, as with any habit, merely establishing the intention to break the habit is not going to be sufficient. There are going to be other things that are going to be required if we're going to try to address these spontaneously activated, very well-practiced kinds of associations. And so I've argued over a great many years that breaking the prejudice habit is likely to involve intentional effort over a protracted period of time. And one of the really important things about this is that if you think about if you've tried to break any habit, whether it's cracking your knuckles, biting your nails, whatever it would be, those types of habitual responses are revived from time to time. In the process of breaking the prejudice habit, people fall into their old habits only to have to redouble their efforts. And I've been interested in the extent to which we as social scientists might be able to offer people any type of assistance in this process of breaking the prejudice habit. So like breaking any habit, there are going to be a number of necessary ingredients to put together to assist people. The first sort of criterion or set of things that will need to be satisfied is that the person has to make the decision to break the habit, because without motivation, nothing is going to happen. So motivation is going to be an essential ingredient. The second ingredient is awareness of the bias, and we really conceptualize awareness in a couple of different ways. First, people need to be aware that these biases exist in society and that these biases can be linked to discriminatory outcomes. Could we help people to understand the nature of the challenge by sharing with them evidence linking implicit biases of the sort that Mahzarin's IAT measures with discriminatory outcomes, talking about the research, for example, that she published in the medical journal linking doctors' biases to the failure to prescribe important medications. If we were able to provide them that type of information, it might be useful to them in developing a concern over the nature of these types of biases. But a second way in which awareness is important is that people need to know that, in fact, they possess these biases. They need to take things like the IAT or have other sorts of indicators that would reveal to them their personal level biases. Because very often what I found in teaching my students and talking with people, they said, I'm not prejudiced. I decided it's wrong. But they haven't recognized that that's merely the first step in this, what I would argue is going to be a long-term process. In revealing to them their own personal biases combined with that type of evidence, it might help them to recognize the ways in which they may be unwittingly complicit in the perpetuation of bias. And that might be meaningful information. The third thing that people need, the third ingredient, is that they need to know how to overcome the bias. Early in my career, I argued if people were motivated and they tried hard enough, they really could overcome these biases. But where I had been perhaps not helpful enough is that I didn't provide them with tools or strategies that would assist their efforts if they were sincerely motivated to overcome bias. So I'm going to argue having those types of tools is going to be necessary to assist people in their efforts. Now, one of the things I think we need to do, as I said before, is to be realistic, that if people become motivated and they are concerned, they become aware of their biases, that it's going to be something that is not going to happen immediately, it's going to happen over time, and so I'm going to argue we need to study people over time. We need to monitor their progress, if you will, in their efforts to break the prejudice habit and bring their implicit responses in line with 2 minutes? Patrick, you took too long. All right, very quickly, what we did is we actually developed an intervention that tried to pull all of these different ingredients together, all right? So this is going to be a multifaceted intervention that is directed toward trying to provide people with education about the nature of bias and the ways in which they might be complicit by giving them feedback. And then we taught them various strategies that, if practiced, could assist them in reducing their implicit bias, might make them more sensitive and aware over time of their tendency to show bias, and it might enhance their concern about responding with bias. And what we did was to provide a 45-minute narrated interactive slideshow that had these various elements that would educate people about bias, provide them with feedback, and then taught them strategies such as taking the perspective of others. That's not a magical strategy in some ways. I mean, people have talked long about this, but I don't think people have thought about, ordinary folks have thought about how to integrate that into their everyday experience in a way that could be powerful in combating their own implicit biases. So we provided them with a toolkit of strategies. There were 5 in total. If you're interested in the details of the work, we can send you a paper. But what we then did was to monitor them over a 2-month interval where we were able to provide them with opportunities to report their bias. This is a schematic of the study. I'm just going to put all of this up here right now. I mean, what you can see is that we measured people's baseline self-report measures, their level of concern, their level of awareness. And then at week 0, we had assessed a baseline IAT. And we gave them the education and training program. And then we followed them over the course of 8 weeks, where we were able to measure their self-report experiences and their IAT reactions over time. Let me just jump to the conclusion. Right now, we compared them to a control group who was only given feedback about their level of implicit bias, no education, no training, yet they completed all of the measures. Our training was effective. And what we showed was that on a measure of implicit bias, and it is the IAT that Mahzarin, Banaji, and her colleagues developed, we showed that our control participants maintained their original level of IAT bias, but our research participants who took our tools with them, exported those tools into their everyday life, showed a dramatic decrease in their magnitude of IAT bias by week 4 that was sustained over the course of the 8 weeks following the intervention. On our measure of concern, we found that our control participants, though they had feedback about their IAT, they became no more concerned about discrimination. But our participants in the intervention group increased in their level of concern. They increased in their level of awareness of bias. They became sensitive to the fact that they displayed bias, and then they went to the techniques to try to correct that. And what we found is that it turned out that the people who reduced most in their IAT bias, this implicit, previously thought to be uncontrollable type of bias, those who were most concerned during the period when they could practice the techniques, so this is at our week 2 assessment, they are the ones who showed the most dramatic reductions in IAT bias, and that was maintained over the 8 weeks of our intervention study. One of the things I'll suggest here is that effort, it turns out, was related to the reduction in implicit bias. Those who reported practicing the techniques, actually implementing and trying to overcome the bias, showed this type of the greatest reduction in their IAT bias. In a follow-up study, what we found was that those who felt most guilty about their IAT bias, over time, they are the ones who showed the most dramatic decrease in the magnitude of bias, suggesting to us that this is, in fact, a motivated process. And if we are able to instantiate sufficient concern and help people to become aware of their biases and actually teach them strategies that they could practice in their everyday lives, it looks encouraging, at least from our vantage point, that people can start to break the prejudice habit. So we're very encouraged by identify these kinds of things. We're very excited about this pattern of findings. It suggests that these types of biases are not as immutable as I may have once thought, although I was ever the optimist, so I always thought there was some way that we could try to reduce these things, and now I feel good that I've done something hopefully useful. But there are a lot of questions that remain, and I'm wrapping up, okay. One of the things that when I look at some of our data, I'm troubled because there are some people who still aren't concerned. And those people are not working on reducing their bias. And we need to figure out ways, it's a different research question, but we need to figure out ways to reach those individuals so that they may develop the type of concern and motivation that would sustain efforts to break the prejudice habit over time. We haven't figured that out yet. It's something that we'll be working on. Another thing this research doesn't address, and it's something that Patrick talked about earlier, is it doesn't directly address institutional forms of bias and discrimination. Yet, if we engage individuals in the process of trying to combat bias, we may actually find an audience who could help with those institutional types of bias. But as I thought about this audience, one of the things that had occurred, or as Patrick and I thought about this audience, there are some interesting questions our findings raise for legal scholars, and I'll just highlight them, and then I'll finish up. And one of the things that it seems to be important is that if implicit biases, once thought to be very difficult to control, can be controlled, what about responsibility? So we could talk about intent, and some people have that, but responsibility to control bias is then an issue that comes into focus, right? So I'm really interested in the reflections that the legal scholars have about this issue. The social science evidence can't resolve that issue. We're starting to think about it, and Justin has invited us to think about these issues in a deep and meaningful way, and we will. But I'll be interested in the kinds of reflections that you all have about this issue. What I am absolutely, totally convinced about is that although the social scientists can offer individuals some assistance in combating their personal biases, if we are to create a fairer society, it's going to require a coordinated effort among social scientists, among politicians, among legal scholars, and lay people alike. It's going to have to be a joint effort, and my hope is that we will continue to offer some tools that will assist people when they embrace the challenge. Thank you.
Thank you, Dr. Devine and Patrick. Our next speaker is Sam Sommers. Sam is Associate Professor of Psychology at Tufts University. He, in my mind, I think is most well known for his work on how diverse juries actually outperform homogeneous juries. They process information better, they exchange more information, they talk about more facts, they correct each other more often, and this has been a very influential work, and that was just at the beginning of his career. He is also a rock star on the psychology and law conference circuit. Every time I go to that conference, everyone's like, oh, there's Sam Sommers. And he's a Yankees fan, which is not good. No. This is Boston. Okay, Sam Sommers.
It's great because Mahzarin stands here and tells you about how it's important that you feel similarity with someone. And then Justin introduces the white guy to talk about race by saying he's a Yankees fan. So thank you. It's nice to be here. I'm actually not going to talk about my research. I made a concerted effort today I'm going to give you a brief discussion about efforts to share the kind of work that I and my colleagues here on this podium and elsewhere have done in the field and how we can apply that to the legal system in a very real, concrete fashion. That is something that sometimes when you talk to scientists is met with bristles of, why would you want to do something like that? To which my response is, well, I'm tenured, so I can do that now. But it is an obstacle in our field among scientists, among some scientists, that the effort to try to apply what we do theoretically, scientifically, to the concrete here and now of a specific instance is a fool's errand and is not that scientific for that matter. And to that I say, hogwash. I say that those of us who entered the field of, say, social psychology to study the psychology of everyday phenomena of everyday life, if the applications of what we're doing to the real world are not interesting to you and important to you, then you're in the wrong field. But what I'd like to also make the point of, I don't feel I need to defend the idea here of applying our research to real cases, to real world domains, but I will do so in the brief sense of saying to students out there, graduate students, other scientists, and so forth, we learn a lot about the theory behind how human nature functions from these quote-unquote so-called applied research ventures. As Justin discussed, I've done research on how a jury's racial diversity affects its performance. That has clear legal application, but it has also shaped the last 3 or 4 years of my research, which really hasn't had a legal bent, but has more looked at diversity more generally and how heterogeneity and homogeneity affect us more generally. Mahzarin is absolutely right when she talks about discrimination in this era being quite often the result of benefit of the doubt or leniency and positive outcome afforded to in-group members that is not afforded similarly to out-group members, and I think that that's something that will shape the way we think theoretically about the issues of in-group, out-group. For that matter, take this slightly afield and think about Elizabeth Loftus and her colleagues and all their great work on eyewitness memory and how that's profoundly shapes and affects those in the legal system today, but has also changed the way cognitive psychologists everywhere think about memory. What I'm going to talk about, and do so briefly to get us where we need to be here, is to talk briefly about expert witnessing and how we translate all that we're talking about here today to the law and what the challenges are of doing that. I mean, there are a lot of answers to a question like, what do we know about race that has relevance for trial proceedings? And I'm not going to spend any amount of time going through the quick bullet points that follow, but we certainly know, for example, the automatic nature of many stereotypes and biases. You've heard about that. We're familiar with the work that Mahzarin and Tony Greenwald and Brian Nosek and a wide range of other researchers have done on these counts. But it's not just the idea that contemporary stereotypes or bias can be unconscious. It's the idea that there are particular circumstances under which these biases are particularly likely. Such as when a great deal of subjectivity has been afforded, when it's a subjective decision, when a great deal of discretion has been afforded to the decision maker, when people are tired, when they're busy, when they're distracted, when you're a morning person and you're making a decision late at night, when you're a nighttime person and you're making a decision first thing in the morning. There are a variety of circumstances under which they're more likely to emerge. We know about the ease with which decision makers recruit ostensibly neutral justifications for their potentially biased decisions. It's remarkably easy for us to give a race-neutral explanation for any potentially problematic decision that we make. And it's why anytime any event happens in our society, whether it's something as serious as the shooting, the fatal shooting of an unarmed teenager, whether it's something involving job practices or other important but not life and death matters, the almost inevitable immediate response is, well, this had nothing to do with race. Sure, race affects people's judgments, but not in this particular instance. And we're very good at coming up with legitimizing ostensibly race-neutral explanations for these kinds of judgments. And the important point to make here, I think, also that the persistence of these tendencies within the walls of the courthouse in having conversations with legal scholars, legal professionals, and so forth, you often run into a belief out there, sometimes self-serving, sometimes I think just simply misplaced, that what happens in a court of law is too serious to allow for these kinds of foibles, these kinds of biases to rear their heads. And we know empirically that's clearly not the case. So what I'm going to do is end just in a couple minutes with a case study, an example of how we can apply these issues that we know about in the real legal system. Let's take capital cases as an example. Within a capital trial, there are multiple different research areas in our field of psychology that speak to issues that come up in a capital trial. The impact of race on jury selection, perceptions, and judgments. This is actually something that I've studied in my research, the extent to which the racial background, the ethnic background, as well as a wide range of other demographics influence you as a litigant, as an attorney, in your perceptions of how good a juror this person will be for my side of the case. There's a clear effect of race on these judgments, even though for over a century, there have been Supreme Court rulings about racial composition and jury pools, but even just since Batson in the last 30 years, we've had a very clear prohibition against these practices. That still is a tendency that emerges. The impact of jury racial composition on deliberations and outcomes, as Justin alluded to, is something else that I've studied in my research. Certainly relevant in many criminal cases, not always explicitly about race, but eyewitness memory, but there is also a relationship between race and eyewitness memory, and it might not be the type of implicit bias we think of most commonly in terms of an affective negative reaction to a certain individual, but there are these unconscious links between the race of an individual and how well we are able to remember having seen that individual and picking that individual out of a lineup later on. And just in general, disparate outcomes and processes for defendants of different races. How does this boil down? How does this come out in an actual case, in the specifics of an actual case? Let's take, as the case study, North Carolina. You're not going to be able to read all this, but the Racial Justice Act in North Carolina. 4 years ago now, the Racial Justice Act, it passed by the legislature, the state legislature in North Carolina, made it the case that if you could demonstrate that, for example, death sentences were sought or imposed significantly more frequently upon persons of one race than upon persons of another race, or death sentences were sought or imposed significantly more frequently as punishment for capital offenses against persons of one race as opposed to offenses against persons of another race, or if race was a significant factor in decisions to exercise peremptory challenges during jury selection, if you could demonstrate that statistically according to the state of North Carolina, then an individual was entitled to relief in terms of having his or her death sentence commuted to life in prison without parole. And to go back to, sort of harken back to how Mahzarin started us off with the call to tell it like it is, all three of those, it is, right? I mean, we have the data on all three of those across a variety of jurisdictions. Do we have it at this point in time for North Carolina 3 or 4 years ago? Not necessarily, but two researchers at Michigan State Law School, Barb O'Brien and Catherine Grasso, ran the study. They collected the data, right? They collected the data for every jury selection that happened for every defendant on death row currently in North Carolina. They broke it down by county, by era, but they looked at the entire sample and found, lo and behold, for point number three there, race was a significant factor. Prosecutors were significantly more likely to challenge black jurors, prospective jurors, using their peremptory challenges, and for that matter, defense attorneys were more likely to remove white prospective jurors during jury selection. So the data were there. But still, what happens in the course of the first hearing here, so in the first appeal heard based on the RJA earlier this year, these researchers testify about these archival data, but there's still an obstacle to be overcome. And that obstacle to be overcome is the belief that many have that racial bias is an intentional thing. It's a conscious thing, and it's an intentional thing. And so what does the state of North Carolina do in response to this at this hearing? They put on the stand a parade of DAs, judges, but mostly DAs who testify about, I never once thought about race in selecting any of the juries that are in that sample, right? I removed that guy because he didn't make good eye contact, and her, and there's a whole, and very plausible at some level, series of explanations one can offer for what went on. That's the defense, though. I didn't think about race, ergo there could not be a racial disparity here to worry about. And so still what's needed in a trial like this, in a hearing like this, is someone to talk to, in this case, not the jury, but the judge, about what racial bias really is in this day and age, and what we know about implicit racial bias. And so I testified in this case about, yes, the work I have done on race and peremptory challenges, but also more generally, what do we know about these kinds of issues that you're hearing about today? What is the nature of the decision-making processes that people undergo in this day and age when they are making a decision, rationalizing that decision, and so forth? The results of that case, which some of you may have read about recently, is that Marcus Robinson, who by all indications, committed a grievous crime and deserves the conviction that that was handed to him, is now serving a life sentence without parole as opposed to being on death row. And there will be continued, I would imagine, until the legislature potentially acts on the RJA, continued hearings in the state of North Carolina based on these kinds of claims, based on data, empirical data, but also contributions from behavioral scientists who are able to articulate for the courts what those disparities mean, and that it's not enough to simply say, I never thought about race, I don't have a biased bone in my body, therefore we don't have a problem, Your Honor. The challenges, there are challenges to doing this. There's, again, the challenge of what lay assumptions about racial bias are. You've heard about that, this belief, again, that bad actions are from bad people, and so therefore if you have good-hearted people, you can't have bad actions. There's challenges of trying to apply what we do as scientists to the courthouse, because what we do is we draw probability-based decisions in our research. We write things that drive our research method students crazy in class. We tell them, no, you can't say that you've confirmed this hypothesis. You need to write the data suggests there is, or indicate there is a statistically significant likelihood that That's the way we talk in science, and that's the way we conduct our data analysis. Translating that to the here and now of how does it apply to this case is always a challenge. And so you, of course, have to be honest about what you can and cannot say as a witness in these cases. But the opportunity is there. And so for those of us who do this work, the opportunity to talk about our own work and also to help translate the work that our fellow colleagues do to the courthouse, in front of a jury, in front of a panel of judges, in the form of briefs when we know that there's a important case pending at a higher appeals court. Along all those lines, that potential is there. And for those of you in the legal system who are on the ground floor working on these issues and fighting for these issues, grab us by the lapels or the blouse or whatever we're wearing, or it's the summer, so polo shirt and sneakers, and shake us and tell us that you have this claim, you have this disparity, you need help explaining it, you want a convergence of research methods to help make that case more compellingly, because I think that kind of collaboration is necessary to make this case in open court or in the court record or whatever the case may be. So thank you very much.